In 1993, the Supreme Court of the United States heard a case about a religion that kills animals as an act of worship. A Florida city had passed a set of laws specifically designed to shut down one church. Not because of crime, not because of safety, because of what its members believed. The Supreme Court ruled against the city, unanimously. All 9 justices. This is the story of Santería, one of the most misunderstood religions in America, and the legal fight that decided whether it had the right to exist in the open. Act 1. What Santería actually is. Santería formed in Cuba among enslaved Yoruba people brought from West Africa. Forbidden from openly practicing their own faith, they preserved it by blending it with the Catholicism forced upon them, mapping their own deities called orishas onto the iconography of Catholic saints. Behind a statue of Saint Barbara, a follower might really be honoring Shango, the orisha of fire and thunder. Today, practitioners estimate well over 1 million followers in the United States alone, concentrated heavily in Florida among Cuban American communities. Animal sacrifice is one of the religion's central acts of devotion, typically chickens, sometimes goats or other livestock, killed quickly and humanely by a trained priest, then cooked and eaten as part of the ritual itself. To practitioners, this isn't cruelty. It's a sacred exchange with the orishas, treated with the same seriousness as any other religion's central rite. Act 2. The city that tried to ban it. In 1987, a Santería church called the Church of the Lukumi Babalu Aye announced plans to open in Hialeah, Florida. Openly, with its rituals practiced in public for the first time, rather than hidden away. The city council's response was immediate. Within months, Hialeah passed a set of ordinances that banned ritual animal slaughter outright. Here's the detail that made this case so important. The laws were written with exemptions. Kosher slaughter was still allowed. Licensed slaughterhouses were still allowed. Hunting and fishing were untouched. The only killing of animals these laws actually stopped was the kind done for religious ritual, which, in that city, at that moment meant Santería. Council members at the time were remarkably candid about their motivations, with several openly framing the religion itself as something the city did not want and should not have to tolerate. The church sued, arguing this violated their First Amendment right to freely practice their religion. They lost in the lower courts. Twice. Act 3. The Supreme Court's answer. In 1993, the case reached the Supreme Court as Church of the Lukumi Babalu Aye versus City of Hialeah. The question was simple. Can a city ban a religious practice using laws that exempt every comparable secular activity? The court said no, unanimously. Justice Anthony Kennedy, writing for the court, found that Hialeah's laws weren't neutral at all. They were built, piece by piece, to target one specific religion while leaving every functionally identical non-religious practice untouched. Under the Constitution, a law that singles out a religious practice that way has to survive the highest level of legal scrutiny. Hialeah's laws didn't come close. The ruling didn't just protect one church. It became one of the most important religious liberty precedents in modern American law, establishing firmly that local governments cannot use the language of public health or safety as a disguise for targeting a faith they simply don't like. Santería still divides public opinion today. Animal rights advocates continue to raise genuine welfare concerns. Many Americans remain uncomfortable with the practice on instinct alone. But the Supreme Court's answer in 1993 wasn't about whether animal sacrifice is comfortable to watch. It was about something older and simpler than that. Whether the government gets to decide which religions are acceptable enough to practice in public. This is sacred and profane. Where do you land on this one? Does religious freedom have to include practices that make people uncomfortable? Let's talk about it below.